Yes, I'm David Shannon. I'm Executive Legal Counsel at the Commonwealth Bank of Australia, and I am responsible for leading a team of 25 lawyers, and we advise the institutional bank, markets, treasury, risk, mergers and acquisitions, human resources, corporate advisory, and major disputes. So it's a large role, there's plenty on, but I'm not representing the bank today. I'm simply giving some insights into how the in-house profession operates and the kind of needs that corporate clients require from both internal and external lawyers. And I'd like to start by saying I was transfixed by Connie Brenton's presentation because, with respect, nearly everything of what she said today rings true for the in-house profession and for, I think, would ring true with most of my colleagues and most in-house lawyers around Australia. Things certainly have moved quite significantly over the years. I joined the bank in 1990 as a lawyer, and I've got nearly 26 years in-house experience. I went to the Commonwealth Bank directly from university, so I really only know in-house, but I see what external firms are doing, so I have a pretty good insight into how things operate. When Gary Ullman phoned me and asked me whether I'd be prepared to speak to the inquiry, he did ask me to comment on the focusing on the needs of the corporate clients from their internal and external lawyers. And so what I can say is that the one thing that external lawyers can do to make themselves of much greater use and to add more value to what happens to the corporate client is to have a much clearer understanding of the markets in which those clients operate, to try and understand their internal policies and procedures, to try and understand the commercial outcomes they're trying to achieve. And if they do that and they get to know the corporate clients much more closely and much more intimately, they will have a much better understanding of what's required, and then they'll give advice and service that is much more valuable to the client in the long run. And you've, as Connie rightly said, and as Claire, I think you said, our clients are much more sophisticated nowadays than they used to be, and you can assume when you're dealing with a corporate client, whether it be a bank or an insurance company or a mining company, whatever it might happen to be, that there is a certain level of commercial acumen and expertise. When they're dealing with you, they will not be dealing with a lawyer for the first time. They will have a pretty good understanding of what the law is, and if you can keep that in mind and then focus on what they really require, you'll have a much better outcome for them. One thing I've seen external lawyers do over the years is they can sometimes be a little condescending in the way in which they present things, and they can sometimes present legal argument in a way which is very difficult to digest. The last thing a client really wants to hear is that Section 75ZZQ of the Act has repealed the First Division, but that takes effect when there's a proclamation, and until then there are savings provisions. Their eyes glaze over. They'd like to know that they can do something or they can't do something, or what the risks associated with a certain kind of conduct are likely to be, or what the legal challenges might be and what the risks might be. And if you bring a commercial approach to this as well, then you really provide a value add.
Great. Thank you. So when you're deciding to engage an external lawyer, what are the major factors at play for you? Obviously cost is going to be one of them, but
Yes.
Is that the only one, or are there other factors at play?
Certainly not. All corporate clients are conscious of cost, but cost is far from the most important aspect. The most important aspect is getting the advice right and getting it provided in a way which is useful. An anecdote I can give without revealing any confidences was that a project I was involved in a number of years ago, we had a large amount of work to be done over a fairly short space of time, and I put it out to 3 firms on our panel, 3 very experienced firms, 3 very highly respected firms, and I set out exactly what I needed done, and I emphasised that the client was very, very cost conscious, and they came back with, each one of them came back with a proposal. My estimate of the cost of this particular exercise was that it would cost somewhere between $350,000 and $400,000. It was a big piece of work. The first firm came back with a quote under $100,000, and when I looked at it, my eyes just nearly popped out, and I thought, what are they doing? And when I went and asked them exactly how they were doing it, it was clear that they were cutting out a number of really important steps. And I said, that won't work. The second firm told us $380,000, and I thought, that's the sweet spot, that's exactly what we're expecting to pay. But again, there were 10 items that needed covering off. There were 5 done really well, there were 3 that were done so-so, and 2 that were missed out that were quite important, and I said, that won't fly either. The last firm quoted $850,000, and they hit everything right on point, but there were also 3 or 4 things that were over the top that weren't required that we could cut away. And eventually we settled on a figure of around about $500,000 to do the work. And the other firms were astonished that we actually went for the more expensive firm. And I said, but they actually focused on what we needed. So cost is not the only thing. Yes, it's important, but if anybody thinks that just by quoting the lowest possible price they're going to get the job, it's not the case. And the other thing, of course, is that the one thing that drives a corporate client absolutely spare is the lawyer that says, yes, we can do it for $150,000 and the bill ends up being $700,000. It just drives them nuts. They would rather have the honest conversation up front. No nasty surprises. Pleasant surprises are fine, but nasty surprises are not.
Yeah, understood. And do you have any examples also, you referred earlier to where there's a disconnect between your external advisors thinking they know your environment but they don't, or not understanding your policies?
Indeed. Yes, and sometimes this this can be a source of some embarrassment. We had a situation a number of years ago where a number of people in the organisation required some advice about insider trading. And an external firm came and presented an immaculately accurate summary of the law of what was insider trading. Unfortunately, we have internal policies that are actually much stricter than that. If you've got people working in departments who may actually have access to price-sensitive information, we say you are designated employees and you can't trade in the company's securities at all until there's a trading window. So although they may not have any price-sensitive information, they can't trade. And they suddenly went out armed with, oh, okay, we're right to trade. And we said, no, our policies prevent it. So sometimes not understanding the organisation, not understanding its policies, can lead to advice that doesn't help.
So those employees could potentially have been faced with sacking?
Correct.
Yeah. Okay. Any questions from the panel?
David, in your briefing notes, you made mention of external counsel demonstrating an encyclopedic knowledge of the subject matter, and I heard the Group General Counsel of BBC speak a couple of weeks ago, and I thought she said the same thing but in a much different way, and I just love this quote. She said that God didn't ask Moses for a weather report. God asked Moses to build an ark, and I just think that really sums up what we do in
Correct.
in-house roles.
Yep.
We build arks and we expect our external counsel to help us build arks.
That's exactly right. It's the old story about asking the time and being told how to build a clock. You get the same thing.
Totally.
Yeah.
What I wanted to ask you a question about, David, and it's the topic of what this whole commission is about, is the future of legal profession. And I wanted to ask you, without going into any commercially sensitive information, how does the bank select its legal panel? How does it select its external service providers? And then the second part of my question is, how do you see that changing going forward, given the different way that we're expecting that in-house clients and other clients will be looking for legal services in the future? Do you see your role in the bank and the panel changing, or do you feel it will, with big purchases of legal services, do you think it'll stay the same?
Well, to the first question, we have a pretty open process for setting up a tender, and it essentially asks the potential panel firms to give a description of what it is they do and why they should be considered, and to point to the areas of expertise in which they are going to operate, to provide us with examples of other kind of value-added material that they're going to do for us. It might be seminars, it might be providing library services, or it might be providing secondees, all sorts of other things. And then what we do is we look at all of them and look at the strengths of the various areas in which they practice. We also then have a series of gate openers. What are their approaches to things like conflicts of interest, saving of sensitive material? Excuse me, a bit of a frog in the throat. And once we've assessed all of those gate openers, and we also look at things like insurance levels and things like that, we then satisfy ourselves as to which are the ones who should be on the panel. And then last, and probably not least important, but certainly one of the factors down, is what are their rates going to be?
And do you see that changing?
That's how we. Yeah. No. The model works. So it's unlikely to change greatly. But like all corporate clients, we are most interested to see how the profession can think about changing the way in which they charge for their services. We, like all corporate clients, I think we find the time recording method as being a little bit antiquated, and we do from time to time talk to our service providers about what are you actually providing and what's the right level of price for that service. And to the example I gave earlier, that was another example where the price was really not the most important thing, but we did need to land on a price, and we did need to make sure we were getting the right service.
Pay peanuts, get monkeys.
Correct.
Just a quick question, if I may. David, you mentioned the corporate client, and I love the analogy of the detailed encyclopedic advice as opposed to the practical advice. I need something to go away with. Just wanted to, I guess, put to you that often government clients are now stepping up slowly to becoming a sophisticated client. And there's a lot of pushback. I recently heard at a large conference of 180 plus senior public servants be openly critical of the 10-page detailed advice that frankly they could do nothing with. Yeah. So they put it in a drawer and then made a decision on their own. Yeah. Do you have a comment on your interface with government as a client as opposed to a corporate client, and see any similarities in the procurement of legal services there?
I'm not that close to how government operates. I'm not really in a position to talk much about how government lawyers provide their service. But I am sympathetic to the idea of the lack of utility of a 10-page advice without a clear recommendation or a clear commercial observation. I say to all of my team, and I encourage all of our external providers, the best thing you can possibly do is have up front a nice, short, executive summary of what your advice is and why you've reached it. And then if you want to set out in chapter and verse why you've reached that and what the High Court said and what the Act says and things like that, so that a lawyer reading it afterwards can understand how you've come to that conclusion, that's fine. But the simpler it is and the more commercially focused it is, the more useful it becomes.